Good afternoon, ladies and gentlemen. It's an honor to have the opportunity to address such a distinguished audience. I'm sorry I couldn't come to Edinburgh, and many thanks to Mr. Tom for allowing me to record this video instead. My paper today is titled Neither Quiescent nor Rebellious, Legal Obligation in the Time of Necessity. In this paper, I address the ulama's response to various forms of oppression that plagued the quotidian life of Egyptians in late Ottoman era. I show that the ulama were not quiescent against the rulers' oppression. Rather, they decided to align themselves with the people's side. They developed new fatwas and reformed the Islamic political theory in order to accommodate the peasants' resistance to the state injustice. The ulama introduced a different theory for what they perceived as a time of necessity. In that time when injustice and corruption prevailed, and the rulers were no longer the protectors of the community but their oppressors, at least according to some ulama's perception. The ulama decided to appoint themselves as juristic reviewers over the political decisions of the rulers. They arrogated to themselves the right to quash the rulers' decisions even if they didn't strictly contradict Islamic law. This judicialization of politics was motivated by the rise of the discourse of fasad al-zaman, corruption of our time. I will present two unprecedented theories developed by the Shafi'is and the Malikis respectively to delegitimize some of the decisions of the ruler even if they didn't challenge Islamic law. Nevertheless, at the same time, the ulama remained loyal to the political legitimacy of the rulers and didn't adopt a rebellious approach. They navigated a third way between quietists and Kharijites. This represents an innovative attempt to restrict the authorities of the tyrants without resorting to armed struggle. In the following, I will discuss two theories. The first theory, developed by the Malikis, claims that if the ruler or his employees were not just, his authority would be transferred to the Muslim community. The delegation given to the ruler as a representative of the Muslim community would be withdrawn back to its original holders, the public Muslims. Sheikh Muhammad Alish, the 19th century Egyptian scholar, was once asked about a divorced woman from an honorable family who had no relatives. She got married to a husband equivalent, and he gave her the due dower. As she didn't have relatives, she selected a man from the public Muslims to be her marriage guardian. As the wedding was made, with the attendance of a considerable number of Muslims. After the marriage was consummated, someone came to claim that the marriage was void because the judge should be the woman's guardian when she had no relative, not a man from the public. Sheikh Alish answered that the marriage was valid and that the judge had no legal authority to annul it. He justified his opinion on the basis that judges at that time were missed, and what was found then was just nominal titles with no meaning in reality. Therefore, the judge had no competence to be a guardian, and any person from the public Muslims, Jama'atul Muslimin, would be eligible to be the guardian. This fatwa clearly contradicts the established opinion of the Maliki Mazhab, which entails that the ruler or the judge is a subsequent legitimate guardian when the woman has no relatives. Alish fatwa is not an extraordinary one, but it's an implementation of a general principle that Alish uncovered elsewhere. He argues that the just members of the Muslim community supplant the ruler in this issue, and in every issue they found that it's not possible to reach out him or if he is unjust. I contend that this is a groundbreaking theory as it delegitimizes the ruler and strips him partially of his legal authorities if he is unjust. The solution that Alish proposes transcends the duality of legitimacy rebellion that inhabited, nay, dominated the minds of Islamic political theorists in the previous centuries. Alish doesn't endorse an armed rebellion, nor envisions the permissibility of dethroning the ruler, an approach that was repugnant to the ulama for its devastating consequences. Instead of legitimizing the armed insurgent against the unjust ruler, Alish suggested that he would remain a legitimate ruler. He believed that the Muslim must obey him. However, he occasionally delegitimizes some of his orders, authorities, and decisions when he envisages that observing them contradicts what he perceives as the public interest of Muslims. What's at stake in this case is the legal legitimacy of the decision, not the political legitimacy of the ruler himself. On some occasions, Alish addresses both the rulers and the Muslim community to ask them to enforce his own fatwas. For instance, he is asked about the ruling of wandering the village's street while carrying the coffin of the dead, inasmuch as his body would decompose, يتفسخ, a common custom that was practiced somehow before burying the body of the dead in the 19th century Egypt. Alish answered that this custom was a prohibited innovation, bid'ah, and therefore it's obligatory in those whom Allah has given the authority of ruling and on the Muslim community to formidably prevent them and to harshly castigate and deter them. If this didn't succeed, they should be imprisoned and beaten. Otherwise, they will be sinful for approving that appalling, wrong, and hideous nonsense. In this fatwa, it's interesting that Alish casts the responsibility on both the ruler and the Muslim community. If the ruler doesn't prevent them from committing such wrong, the Muslim community should undertake the responsibility to do. Otherwise, the ruler wouldn't be sinful only, but also the whole community. Referring to the Muslim community as a vehicle for enforcing Sharia is repetitive in Alish's fatwas. If Alish expected that the Egyptian rulers or judges wouldn't apply Sharia in that case, he would ask the Muslim community to intervene to apply it. Similarly, he decided to empower the Muslim community of the authority of the Hakim if he knew that raising a case before the official authorities would culminate in an unjust decision against the wronged person, or would it charge him illegal costs. The notion of granting authority to the Muslim community seems to be a development of Al-Juwayni's hypothesis about the extinction of the rulers. Al-Juwayni, in the late Abbasid era, imagined a time where Muslims wouldn't find a ruler to govern them. He suggested that the position of the ruler was indispensable to Muslims, and it couldn't be left vacant, according to both religion and rationality. Although Al-Juwayni was concerned with the instance where Muslims have no ruler, later Ottoman Malikis extended it to the case of unjust rulers. They claimed that an unjust Muslim ruler equals nullity. I believe this constitutes a dramatic development to Al-Juwayni's notion. Khalil, the author of the famous Mukhtasar, who lived in the Mamluk era, affirmed that it was not allowed to raise a claim to the Muslim community while the Muslim ruler, whether a governor or a judge, is available. However, Sheikh Ali Al-Adawi, for example, suggests that, who is a 19th century scholar, suggests that the existence of the judge or the other people Khalil mentions, while they are not just, is equal to nullity. Therefore, the case can be raised before the Muslim community. Similarly, Sheikh Dardir argued that the absence of the ruler shouldn't be in reality, as they may be existent, but their existence was similar to their absence. At our time in Egypt, he says, where there is no Shari'i law, as in our time in Egypt, where there is no Shari'i ruler. Also, Sheikh Sawi, who died in the 19th century, agreed with Sheikh Ahmed al-Dardir that the existence of an unjust ruler was meaningless, and the real ruler should be the Muslim community in this case. I will now move to discussing another theory developed mainly by the Shafi'is and to a lesser extent the Hanafis about the authority of judges in the 19th century. Judges were perceived as representatives of the state in as much as some juristic literature uses the word hakim to refer to them. With the domination of taqlid, the ulama lowered the qualifications required for the position of the judges, the same way in which they used to simplify the conditions of the caliphs. Early theories had stipulated that judges should be mujtahid. However, later on, the ulama allowed the appointment of a muqallid judge. Also, rulers were more inclined to appoint judges who were not utterly upright Muslims to ensure that they wouldn't oppose their tyranny. The ulama found themselves obliged to legitimize the ruling of those judges. Otherwise, if the ulama delegitimized their decisions, that could cause the society to slip into disorder and chaos. This theory that granted legal legitimacy to unqualified judges for reasons of expediency was referred to as the theory of Qadi al-Darura, a judge of necessity. Although the theory of Qadi al-Darura was first developed by the ulama to legitimize the judge's decisions, the same theory has been invoked by late scholars to limit the authority of judges. Late Ottoman ulama suggested that the decision of the judge of necessity can't be valid unless its reasoning proved valid. In Tuhfat al-Muhtaj, for example, he stated that many late scholars argue that the judge of necessity who doesn't meet some of the aforementioned conditions needs always to elaborate the rationale of his decisions, and that he can't make a decision about a case without declaring its reasoning. This principle empowered the ulama to reject some of the judge's decisions on the ground of its ambiguity or generality. For example, Shihab al-Din al-Ramli argued that if the judge is asked to reveal the justification of his decision, bayan mustanadih, he should do that. If he refused, he means the ulama, would avert and it wouldn't be approved. In the 19th century, Sheikh Muhammad al-Marakeby wrote a short treatise on this subject matter after a question was sent to him by some Yemeni ulama. The questioner asked about a judge who was informed by witnesses that another judge issued a given decision. The question asked, should the second judge approve the decision of the former even if the witnesses didn't elaborate the details of the case, nor the proof on which he means the first judge, based his decision? The questioner elucidates that Shafi'is affirm that the judge of necessity needs to explain the proof of his decision in all cases brought before him, because of the weakness of his authority, ضعف ولايته, and because he might think of something as a proof while in reality it's not a valid proof. Al-Marakeby answered that referring the judge's decision to another doesn't necessitate the latter to rejudge the case. In this instance, the position of the second judge is just to execute the decision of the first, even if he doesn't know the details and circumstances of the case. Al-Marakeby suggests that this is the standard doctrine adopted by the ulama. However, he argues that if the first judge is a Qadi al-Darura whom we don't trust his knowledge or his religiosity, then the second judge should investigate the details and the proof of the case before he approves it. Al-Marakeby underlined that what is at stake in this case is whether the first judge is a pious and knowledgeable or not. If he says, if he is a judge of necessity, then there is a double reason to check his proof. Seemingly, Al-Marakeby wished to unpack the concept of Qadi al-Darura and to differentiate between two kinds of Qadi al-Darura. The first is the one who didn't reach the status of ijtihad, but he is still religiously and scholastically competent to be a judge. Al-Marakeby doesn't consider the judge needs to reveal the rationale of his decision to be accepted. The second type of Qadi al-Darura is the depraved judge, who is not competent to hold the position or who lacks the required knowledge of Islamic law. Al-Marakeby affirmed that this judge needs to delineate the details of the valid case that was brought before him and to justify his decision. Restricting the authority of late judges doesn't seem to be an exclusive Shafi'i doctrine. Hanafis also adopted the same principle of Qadi al-Darura when they found it necessary. Ibn Nujaym stated that the fatwa that should be followed at our time is that the decision of the judge shouldn't be accepted without scrutiny, mu'ayyana. Ibn Nujaym is asked about the decision of a judge in which he affirmed that this endowment has met the legal requirement of replacing it, istibdal. Ibn Nujaym replied, I answered many times that this is not sufficient. Ibn Nujaym argues it's not sufficient for the Qadi to state his decision without providing a convincing reasoning for it. He suggests that the ruler's authority is limited to the scope of public interest. Then he adds that what the ruler perceives as public interest should comply with the real public interest on the ground in order for his orders to be obeyed. Ibn Nujaym arrogated to himself the right to define what the real public interest is. In Tanwir al-Absar, Tomurtashi states that if a judge orders you, he means if you were flagellant to kill, dismember or flog a convicted person, you are allowed to do that. However, another opinion attributed to Muhammad ibn al-Hasan al-Shaybani suggests that the flagellant shouldn't enforce the decision of the judge until he knows the judge's reasoning. Mullah Khisro argues that this is the most suitable, he means the opinion of Muhammad ibn al-Hasan al-Shaybani. This is the most suitable opinion to our time, as judges became corrupt and they can't be trustworthy of people's lives, bodies, and money. This sounds peculiar, as how the executor, who is not an expert in Islamic law, know if the judge's decision is fair or not. Ibn Abdin, in response to this question, suggests that the flagellant needs to seek the affirmation of another just judge before he executes his order. Interestingly, some ulama didn't see this notion as limited to judges only, but as a general dictum that could be extended to any official who was not trustworthy. The son of Ibn Abdin comment on the above question about the order of the non-trustworthy judges, saying this implies that the orders of the ruler in our times don't signify an obligation. To conclude, this paper shows that the ulama were not quiescent against the ruler's oppression. Rather, they decided to align themselves with the peasant side. They developed new fatwas and reformed some Islamic law rulings in order to accommodate the Egyptians' passive resistance to the state injustice. More importantly, this paper elaborates how the ulama introduced a different theory for what they perceived as a time of necessity. In that time, when the injustice and corruption prevailed, the ulama decided to self-appoint themselves as juristic reviewers over the political decisions of the rulers. They arrogated to themselves the right to reject their decisions, even if they didn't strictly contradict Islamic law. However, at the same time, the ulama kept loyal to the political legitimacy of the rulers and didn't adopt a rebellious approach. They navigated a third way between quietism and Khawarij. This represents an innovative attempt to restrict the unfettered authorities of the tyrants, and this attempt was led by a group of ulama who were usually referred to as conservative, rigid, and backward, not by the well-known reformists of the 19th century whose call for constitutionalism were intensively studied. This draws attention to a different attempt of legal and political reform that didn't simply mimic the modern one. Thank you very much.